All right, looks like we've slowed down. So I'll go ahead and get started. Welcome, everybody. My name is Ryan Payton. I'm the director of the Colorado Attorney Mentoring Program, and I'm so glad that you've joined us today for our first CLE event of 2022. Well, we're going to be focusing on well-being as an aspect of lawyer competency, and I'm really excited to have this conversation today as it's come up quite a bit over the last few months, certainly during the pandemic, and anxious to talk with our panelists and get their points of view. A couple of housekeeping tips for you as we're underway here. We are in webinar mode, so I can't see you or hear you. If you're having tech trouble, my best suggestion to you is to sign out and sign back in. That's usually the hard reset that folks need to get their computer resituated. We also do have live transcription and closed captioning available if you need it. You can just click that button at the bottom of your screen and select subtitles, and that will provide you with a rolling closed captioning if that's of use for you. And then CLE credit, what I'm going to do actually right now is upload a couple of documents into the chat box for all of you. What I'm uploading is both the CLE affidavit as well as a handout that Professor Austin has put together for us and will reference as we have our conversation today. So definitely download both of these documents and make use of them as needed. We will have time for questions at the end, so hold them until then, but you can put questions in the Q&A box if you would like, and I will relay them as we go along. So with that, welcome again. I'm so glad to be having this conversation. And before we get started, I'll have the panelists introduce themselves. All three are fantastic experts in the Colorado legal community regarding lawyer well-being and law student well-being, as well as civility and professionalism. And so I'll start with Sarah Myers.
Thanks, Ryan, and hi, everybody. Happy to be here. My name is Sarah Myers. I'm the Executive Director of our Lawyer Assistance Program here in Colorado. Professionally, I'm an attorney. I'm a licensed marriage and family therapist, licensed addiction counselor, and licensed educator. So you probably get a sense I come at things from kind of that cross between the clinical, educational, and legal perspectives on things. So.
Great. Thanks for being here, Sarah, and thanks for everything that COLAP does for the community. Next, I'll turn it over to Professor Deborah Austin.
Hi, good afternoon. I teach at the University of Denver, Sturm College of Law, and my research is focused on neuroscience and psychology. And so I come at the lawyer well-being topic from those perspectives.
Great. Thanks so much, Professor Austin. And then finally, Jonathan White with the Office of Attorney Regulation Counsel.
Hey, good afternoon, everyone. I'm John White. I'm Professional Development Counsel and Inventory Counsel here at Office of Attorney Regulation Counsel. With Professional Development Counsel activities, I work on our office's educational programming, including the Lawyer Self-Assessment Program, which some of you may have heard of. And I have also supported our office's efforts to support both the National Task Force on Lawyer Wellbeing and our Colorado State Task Force on Lawyer Wellbeing. I had the great opportunity to work with Sarah on the National Task Force on Lawyer Wellbeing, as well as Sarah, Ryan, and Professor Austin on our State Task Force on Lawyer Wellbeing. So that is my Professional Development Counsel hat. Inventory Counsel, whole other thing we could get into a separate webinar, but that is winding down the practice of a lawyer who has unexpectedly passed away and someone needs to step in and secure client files and funds and trusts. So that's the other hat that I wear here. So good afternoon, everyone. Look forward to the webinar.
Thanks, John. And yes, you do wear many hats and do many things. And we should have another webinar on inventory counsel and everything that is involved in the wrap-up of a practice. Well, thanks for talking about the National Task Force on Lawyer Wellbeing, because that's where I want to start with everyone today, because I think it really is the best place to get a sense of where we were, where we are, and where we're going. And so, Sarah, I'll start with you. If you would give us just a little bit of background for those who may not know about the 2017 Task Force report and really what it said about the state of lawyer well-being, at least at that time.
Great. Thanks, Ryan. And I guess we could probably put the link to the report in the chat. I can do that once, or if you want to. But basically, in 2015 and 2016, extensive research was done on members of the legal community and behavioral health issues. So that kind of spanned from not just mental health, but also substance use and stress, and looking at what was going on, because the research prior to that was in, I believe, the 80s, and it was a smaller research study. Obviously, you can imagine how those results came out, and they were actually pretty similar from the 80s into the 2015 and 16 research, which was that lawyers had higher rates of self-reported behavioral health issues than the general public. Part of the research that was particularly concerning, however, that was new, was that it wasn't just individuals who were seasoned in the practice, maybe getting close to either retirement or burnout, but that those new to the practice of law within the first 5 years were self-reporting these kind of issues in a high rate as well, which for a long-term trajectory of sustainability of the practice made us very concerned. And just to give you a sense, at that time, again, this is a broad spectrum of issues. And so a statistician would probably have my head for this, but if I was to combine all of those, the mental health and the substance use issues, the general public dealing with these issues at a rate of maybe 8 to 15%. Lawyers, it was closer to 20 to 40%. So we did have statistically a much higher rate of issues like anxiety, depression, problematic drinking, things of that nature. And so many stakeholders across the country got together, from regulatory agencies to bar associations, lawyer assistance programs, of course, mentoring programs, you name it, although there are far less of those. But we were all involved in looking at, all right, we've got this research, what can we do about it? How can we change the culture of the practice of law in a way that the profession itself is not increasing these issues for people? Although, to be fair, many of us came into the profession with high levels of perfectionism, the type A personality stuff that lends itself well to things like anxiety, because of many of the different cognitive skill sets that are needed in the practice of law from a clinical perspective can lead to some neurosis of overthinking and over questioning things and perseverating, for example, on an issue. So the task force wrote a report that addressed several different areas, including law schools, the judiciary, firms, and with ideas, which I believe, Ryan, you put that in the chat. So that report is out there with suggestions. One of those, of course, was for states to create their own task forces, which we had in Colorado. And I'll turn it over if John or Deborah or Ryan, you want to go into our Colorado task force, then picked up the mantle at that point in time to look at what we could do in our state for those issues.
Yeah, absolutely. And so John or Deborah, do you want to chime in about the work of the larger task force? And then we can sort of talk about some of the major projects that have come out of that in the last 2 years.
Go ahead, John. I'll follow
I was
you.
going to say, you are welcome to cover it, but I'll be happy to talk about our state task force. As Sarah said, this was born out of the National Task Force on Lawyer Wellbeing's call to have individual states develop well-being task force for the legal profession in that specific state and look at state-based solutions to lawyer well-being issues. So we had a task force that formed here in Colorado under the leadership of Justice Monica Marquez of the Colorado Supreme Court. It first met in September of 2018, and it recently concluded its work in November of 2021 with a final report. We'll make sure that that final report gets dropped into the chat as well. Just in the ballpark of 60 lawyers, judges, and law students from around the state, as well as professors, academics from both DU and CU participating in that. And they looked at really 5 areas of interest. One was, what can we do to get businesses and law firms into the conversation about lawyer well-being or about the well-being of their staff overall? Because fundamentally, one of the things the National Task Force said is, look, this is a bottom line issue. It's about efficiency. It impacts, to the extent burnout, fatigue, mental health issues, substance use issues impact productivity. That impacts the firm's bottom line. So one of the groups in our state task force looked at how do we get businesses in firms into this conversation. Ryan, I will probably defer to you to talk more about the great results that came out of that group. Another group that convened was the Law Schools Committee to look at what are solutions to well-being issues that we can propose for law students. Professor Austin was incredibly active on that front. So Professor Austin, I leave that to you to describe some of the findings and suggestions there. Other groups looked at how to promote well-being among Colorado judicial in the Colorado judicial branch and among judges in our state. A number of different suggestions came out of that group, including let's create a standing committee on judicial well-being, which began meeting in 2021. That group also created a website for judicial well-being in Colorado, which nicely, for those of us who are just practicing lawyers, that's available to us too, or those of us who want a resource for our staff. It's a great resource. Here's why. It's got information on everything from, hey, how do I go find a COVID-19 vaccine, to how do I address burnout, to what do I do if I'm navigating the waters with aging parents. There's a lot of real practical issues addressed there. I'll be sure that website gets dropped into the chat. The other two groups were the data gathering group. There was a group that convened that said, we have seen the national statistics. We don't know if those are necessarily going to be mirrored in Colorado, but our gut is that they're probably very similar. But let's look at what are some forward-looking pieces of information that we can gather about support networks that Colorado lawyers turn to. What else do lawyers think would be helpful to them as they navigate the demands of our profession? So that was the data gathering group, and they proposed different ways to survey that. Last, there was a resources group that looked at how do we take the excellent resources through Sarah's program, COLAP, through Ryan's program, CAMP, and build on that really strong foundation that we have in Colorado. So that's kind of an overview of the task force's work. Ryan and Professor Austin, I don't know if you all want to comment more about some of the proposals that came out of the groups that you were involved in, but I do think some of those are really, truly trailblazing.
Definitely, and I'll let you go ahead first, Professor Austin, if you want to talk about the law school group and what you all focused on.
So I'd like to talk about two things. First, the national report briefly, and then the Colorado Law School part of the report. So my work is largely focused on individual well-being for lawyers and judges and law students. And there is a handout that I prepared for today's session so that you could get some of the details. But the national report stated three major purposes. One was to enhance the effectiveness of legal organizations. The second was to improve the professional and ethical behavior of lawyers. And then the third was to help individual lawyers thrive in 6 domains. My work covers the first 3 domains. So intellectual, physical, and emotional domains, but then the additional ones that are listed in the report are occupational, social, and spiritual. So the handout that I put together for you today starts with the intellectual domain, which the report summarized as monitoring your cognitive well-being and fostering ongoing development, of which we're doing today. And that portion of the handout, I really focus on what are the obstacles to lawyer well-being. Then for physical and emotional domains, my work centers on the neuroscience and psychology research that can help us understand how to improve our brain health and our mental strength, which is the second part of the handout in the chat. Going to the work of the Colorado Task Force, the large takeaways are that faculty need more education on well-being issues, just like lawyers and judges do. Law students need more education. And at DU, I teach a class called Professionalism and Well-Being Skills for the Effective Lawyer. Minimizing alcohol at our events. So one of the things we do to try to draw law students is promise them a cocktail. And we're trying to do some different things. So those are some of the big takeaways for the law school portion of the state well-being task force.
That's wonderful. And I'm so glad that the law schools are taking a more broad brush approach focused to well-being. It's not something that was talked about when I was in law school, to be sure. And I did, for those who came in a little bit late, re-upload Professor Austin's handout in the chat, so you can find that there for what she was just discussing. What I want to add to the conversation is the part about the business case group, and what we really focused on was how do we really engage legal employers in this conversation, knowing that it's great if individual lawyers want to take on their own well-being and do the things that are necessary for their own wellness, but there's a competing force of the people that they work for, telling them, how to monetize their time, telling them what the expectation is around work, and it is a competing force that needs to be addressed. So we looked at how can we address that through legal employers, and ultimately came up with a pilot program where what we did is we offered legal employers the opportunity to pledge to do better in 6 goal areas around well-being, including things like compensation, diversity, equity, and inclusion, bringing clients into the conversation, leadership, accountability, and things like that. So they took a pledge to do better in those areas. And then we provided them with a year's worth of collaborative mentoring opportunities, education, resources, tools, so that they could start creating well-being initiatives or improving well-being initiatives within their organizations. And then at the end of that program, we asked them to tell us what they did in their organizations around well-being, how they implemented some of those tools and resources, and how they fulfilled the pledge that they had made. And then we gave them some recognition from the Colorado Supreme Court for those efforts. And so we ran that pilot program last year. It was a very successful program, and one in which the court has green-lighted us to look at implementing on a statewide basis. So we're currently in the process of doing that work. There's a committee that is working together to put in the structure in place to have that be a program that would be available to every legal employer in Colorado. So stay tuned for more information on that. It should be coming toward the end of the year. And I'll put in the chat the link to the final report for that program as well, if you're interested in reading it. So that's kind of where we are as a state and as a profession with well-being. But my question then back to Sarah and to Professor Austin is, well, that's all fine and good, but we've now been in a pandemic for 2 years, continue to be in a pandemic. And aside from sort of the obvious ways that COVID has impacted lawyer well-being, what are we seeing now? The 2017 report is 5 years old. We've been making these efforts state by state, but kind of where are we today with respect to the scope of lawyer well-being?
Professor Austin, I can get us started if you. Is that okay? Okay. So basically, from a COLAP perspective, what we've been seeing over the past 2 years is a very large influx, an increase in calls for assistance and requests for presentations. So just in case some of you are not familiar with our lawyer assistance program, briefly, we are the free and confidential well-being program for all of the judges, lawyers, and law students and their families or their staff's well-being needs. Some of our main mission through Supreme Court Rule 254 is with education, and then with fielding requests for assistance to find resources for various behavioral health or well-being issues, from stress management to problematic drinking. It's a very broad brush program and the topics that we handle. So over the past 2 years, the types of calls that have increased for us that we have been fielding for the legal community, I would say the issues haven't changed, but the urgency with which people are looking for help has increased. And the fact that the sense of overwhelm or stress has basically superseded now any concern people have for reaching out for help. So basically, part of the mission of the task forces, whether it was the national or state task forces, is always to destigmatize behavioral health issues and to encourage more what we call help-seeking behaviors, i.e., we're the ones who help everybody, so we don't like to admit if we have a problem, and it's hard for us to reach out for help for a variety of different reasons. Sometimes it's concern over the level of confidentiality when a lawyer or judge reaches out for help. They're concerned about any implication to their license, things like that. And so what we've been seeing over the past 2 years is that those concerns are far outweighed by the need at this point. So the good news to me, part of that silver linings type way of thinking, is that everybody's stress levels are up, but it's encouraging people to seek support and help more. And through the work of lawyer assistance programs, mentoring programs, and some of the endeavors of these state task forces nationally, what we're seeing are that as a culture, we're embracing well-being more because what Professor Austin is certainly going to discuss, I'm sure, has to do with the fact that when we're stressed from a neuro perspective, we're not going to do well at work. It impacts our relationships because the way we think is altered and changed. So there's kind of bad news in the sense that obviously everyone's more stressed and overwhelmed than they ever have been before, but they're more willing to reach out for help and assistance. And Ryan, to your point earlier, workplaces are more invested and involved. So COLAP has been seeing an increase in requests for all of our ethics CLE presentations that discuss well-being, tips for working with well-being issues and behavioral health issues with that regard. So I think there's more preemptive work to not just mitigate, but also address the needs of employees before they even occur. So those are some of the trends that we've been seeing at COLAP.
Professor Austin, what are you seeing in the law schools?
So I've been seeing the same kind of increase in demands for presentations. My administration asked me to take more students into my professionalism and well-being skills class. And I think our student affairs office is also responding with more well-being programming. I'm also personally being asked to do more CLE well-being programs for lawyers and judges as well. And I think all people in our profession are starting to realize that in our well-being spectrum, many of us may be languishing. Not all of us necessarily are on the impaired area of the scale, although many of us are, but a lot of us are suffering from this sort of lack of mental health or mental well-being that's been called languishing. And I agree with Sarah that they're reaching out for more help, which is excellent.
So one of the questions that we've had today from an audience member, and one that I actually hear quite a bit, is whether practicing law is really something that is accessible to everyone, that folks who are already kind of at risk of high stress and resulting negative repercussions of that should be involved in a profession like this. And Sarah, I know you and I have had this chicken and egg kind of discussion before, is does the profession, invite people who are already, like you were saying, kind of type A perfectionists, and then it just gets exacerbated, or does the profession actually cultivate that in people, or is it a little bit of both? So I'm curious, really, to all of you, how would you answer, that question? And Professor Austin, I'll start with you just because you're already unmuted.
I would say that folks who come into our profession tend to have perfectionist tendencies, possibly imposter syndrome. But I think our profession's zero-sum hierarchical culture exacerbates all of that, or creates in people who maybe didn't come in with those kinds of issues, creates issues for them. When we are competing against one another for grades, for promotions, for billable hours, it's pretty devastating to our well-being. Doctors don't have doctors on the other side of the table trying to kill their patient. So we have a pretty difficult work culture and education culture. And I think that really enhances well-being problems.
Sarah, your thoughts?
Yeah, I would completely agree with that. And going back to your initial question, which one is it? And it's yes, yes to both. Some of the research out there is across the board for those that have higher levels of education. to say it simply, we're harder on ourselves. And then if you have an environment, to Professor Austin's comments and observations, an environment that reinforces already existing, if you will, pre-existing conditions, so to speak, it's going to make it worse for some individuals. And what I will also say is that right now, as we know, certainly nationally, I'm sure globally, but we know for a fact in the US, with the Great Resignation, a lot of people are questioning their career choices right now. At COLAP, when we receive calls from attorneys or judges who are maybe approaching burnout, they certainly have some secondary trauma or compassion fatigue issues, depending on their practice area, or they're just overwhelmed with time management issues. That's another big one. On occasion, we get several per month who are looking at whether it's a change to another JD Advantage job or another practice area. And that's where, of course, COLAP and CAMP work very well together, because there's always that shift. Whether or not somebody is quote unquote made for the practice of law is, to me, kind of secondary just to the issue of where's the right fit. So no, I don't think everybody is right for any profession. You know, it might be something that's, for some people, it's too much. It doesn't suit their personality or the resiliency levels. But more than that, oftentimes we find it's going to a career coach or a career counselor who can help, maybe getting some professional mentoring in another practice area that just suits their temperament more, or what they're looking to do at the stage of life that they're in. You know, maybe it's not working somewhere where there's a billable hour. Maybe it's more of a public position. So there's just all those different factors come in to play as well, I think.
I think that's a great point. And John, I want to get your perspective, and I'm wondering if you can give your perspective in the context of sort of the civility and professionalism aspect of the profession, and how that can exacerbate some of these issues or drive people to the profession who may already struggle with notions of civility with other folks.
Sure. This is a great question, one that has me thinking the following, and this is from my own sort of personal experience. I probably qualify, if there's some tests that can be done, as a perfectionist. I'm hard on myself. I want to, you know, I want to help people. At the same time, I get disappointed when I can't, maybe because I'm too busy. What else? I look at, you know, I try to be professional. When people are not professional, to me, it gets under my skin. This is the same person who it gets under my skin, you know, when I see people not following rules in general. So how do I respond to that? What's a healthy way of dealing with that? Before working on these lawyer well-being issues, I struggled with how do I deal with them. And I didn't have a great, you know, here's what I do, other than I will tell you that for me, at least, the practicing yoga, staying physically fit, and I run a lot, were ways of dealing with these things. But that to me was not necessarily a sustaining thing, even though they were helpful. What I have learned from being involved in this work over the years is, one, we have excellent programs here in Colorado. CAMP provides mentorship, and I think there's a lot to having someone confirm that this thing that you're handling, this struggle, is not unique, and they're not going to minimize it for you. And I think just finding that camaraderie and that empathy can make a huge difference. Similarly, I think the program that Sarah runs and its availability, its confidentiality is, bar none, there's just nothing else quite like it. And what I mean by that is, over here on my wall behind me, there's a 5 steps to reducing stress just here and now. Like, let's say you're getting ready for a hearing. Let's say you're just having a tough day and you need to pause. COLAP has put out, here are some things that you can do that are quick tips that are going to refocus you, to bring the heart rate down, bring the blood pressure down, so that you can stay on tasks. Those things have been helpful to me, but those are things that I have learned from being involved in this work. In terms of this chicken and the egg problem, yeah, our profession may have people in it that are unable to handle the stress. However, I think those people bring to the profession some of the qualities that I mentioned I have, which are those, we want to help people, we want to solve problems. And I think the question is not, is it the wrong place that they have landed, but how do we bring forward their talents and make sure that they can contribute effectively to our profession and give them coping mechanisms that are not, alcohol, that are not, I stayed up stressing about this thing to 2 a.m. and then I wasn't able to sleep and I'm not performing at my best. So that's my take on it. I would agree with that notion that maybe the practice of law isn't for everyone, but even those who do struggle with these issues beforehand, I think have things to contribute. It's about how do we tap into that potential. So that's how I look at this. Ryan, if it's okay with you, I would like to pivot to talking about some of the professionalism studies that have come out in other jurisdictions. I don't want to totally move the
no, you read my mind. That's where I was going, because ultimately, professionalism, civility have a well-being impact. And I think it's been really interesting, some of these studies that have come out, especially during the pandemic. And so I was hoping you would touch on that, and most specifically the study that came out of Illinois last year on professionalism. And I can put a link to that one in the chat as well. And Hannah, I see your question. We will get to that, I promise, in just a minute. Go ahead, John.
Yeah, so everyone, the Illinois Supreme Court has a commission on professionalism for lawyers. And imagine kind of a camp-like program, but that is focused almost exclusively on how do we not just mentor folks, but also enhance overall professionalism in our jurisdiction. Ryan, I hope that that's a fair description in terms of the contrast with camp. Every 7 years, this Illinois Supreme Court supported Center on Professionalism surveys Illinois lawyers on what they see as trends in professionalism. And they just released their most recent 7-year survey. It came out in late 2021 and surveyed Illinois lawyers in August and September of last year. So kind of during the height of the pandemic, as to what trends they were seeing. And I will be sure to put in the chat a link to this survey, but it's really worth looking at. And this, I think, is the best data that's probably out there on this professionalism in the legal profession issue, even though it is limited to one jurisdiction. And I know we're not talking about Colorado lawyers right now, and we can all, pundit this on would it be the same in Colorado? Would it be different? But let's look at Illinois and what they found, because I imagine that there's probably some similar trends. The 2021 survey showed that of the 90% or 90% of the lawyers responding to this survey, and this went out to over 20,000 lawyers in the state of Illinois, said that the lawyers they interacted with on a regular basis were either civil or very civil. But 54% also said that in the past 6 months, they had encountered uncivil or unprofessional behavior from other attorneys in the practice. What were those behaviors? There were 10 in particular that were identified, and then an 11th category of other. The 10 were, and these two were kind of tied for the top most frequently occurring behavior. They were sarcastic or condescending attitude from another lawyer, or misrepresenting or stretching the facts, or negotiating in bad faith. Those were the behaviors that were most commonly reported. Others that were not as commonly reported, yet pretty prevalent in terms of the responding lawyers, what they saw in the profession, were inflammatory writings and correspondence, or in memos, motions, or briefs, playing hardball with opposing counsel on things like not agreeing to extensions of time, indiscriminate or frivolous filings to just protract litigation, as well as inappropriately interrupting others like colleagues, clients, judges, witnesses during a deposition. Less reported, but still mentioned as examples of uncivil and unprofessional behavior by those responding to this study in Illinois were inappropriate language or comments in letters or emails, as well as swearing, verbal abuse, or belittling language, as well as inappropriate comments about a lawyer's age or experience, along with sexist comments, and then also reported racially or culturally insensitive comments. So those were sort of the 10 categories. And again, those first few, sarcastic or condescending attitude, as well as misrepresenting or stretching the facts, were those most commonly reported. But that's what lawyers saw. And what were the consequences of it? When asked about this in the survey, over 90% of those responding said, look, this behavior, it undermines my client's confidence in our legal system, and it probably undermines the public's confidence in our legal system. Over 89%, so almost 90%, said that this behavior prolongs discovery, or if we're doing a transaction, it prolongs the negotiation period. 88% said it increases litigation or transaction costs in matters that they're handling. And then over 95% said this just makes it harder to resolve a matter and to actually reach a resolution for my client. 90% said it makes our practice less satisfying. And over 60%, 61% said they either strongly agreed or somewhat agreed that this behavior discourages diversity in the profession. So those were the consequences that were revealed in the survey. So, you know, what do we do with that data? And is it a glass half full, half empty? If 90% said overall, folks are civil, that's great. But I also know from having been in private practice that all it takes is that one uncivil email or comment that's going to throw off the whole entire day, because that's all you're focusing on. Or if that email hits you at 10:30 p.m. in the evening, that's going to interrupt sleep, right? So again, what do we do with that one example that can have a bleed over effect to other matters that we're working on? And that again is where I go, you know, look at what are the coping mechanisms that you use. I've identified those that I use: yoga, running. If you need help with others, if it's a mentor, look at CAMP. If it's other resources that you support, or you want to talk to someone, look at Collab as resources. That's my take on it. We shouldn't struggle alone on these fronts.
Yeah, thanks, John, for that great overview. And so, you know, my takeaways from that are, civility and professionalism is getting better, but only for some people. It sounds like, you know, for those who are still, you know, for those from underrepresented groups and communities, it's not necessarily getting much better. And I also worry about the fact that 90% say it's getting better, but 60% say, well, we're still pretty routinely experiencing these civility issues. And so are we just becoming more, you know, used to it, to the sense that it doesn't necessarily impact us as much? And if that's the case, that's also very concerning to me. But obviously it all has a well-being impact on what we're doing, and ultimately I think has a competency impact for lawyers. And so that's kind of where I want to take our discussion from here, is really looking at, well, what are the competency implications of well-being, with including civility and professionalism? And so just thinking about that, John, can you just give us a quick overview of Rule 1.1 and what it says about lawyer competency?
Yeah, so for the ethics part of this, everyone, let's look at our rules and what we took an oath that we were going to uphold. So, and Ryan, I'm going to actually go a little bit deeper into the rules to begin with. Rather than Rule 1.1, which is our duty of competence, there's a rule in Colorado that I go, you know, here, this encapsulates the issue. It's Colorado Rule of Professional Conduct 1.16, lowercase a, and it says that a lawyer will not represent a client or shall not represent a client, or if representation has commenced, should withdraw from the matter if the lawyer's physical or mental condition materially impairs the ability to represent the client. Straightforward enough. Now, I don't have a bunch of case law to drop into the comments today to say, here's where a lawyer is licensed, receives some sort of sanction because he or she didn't follow that rule. But I mean, isn't that a call to all of us to say, hey, you know, stop and look at, if we're experiencing these problems, can we ethically go forward with this representation? And I think that rule is saying we really need to be cautious here. Going to Rule 1.1, that is our duty of competence, which says a competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Let's take those last two terms, thoroughness and preparation. If we are working through a mental health disorder or substance use disorder that is going to impact our ability to be thorough, to be prepared for something, it probably will sound in Rule 1.1 as a potential issue. There's other rules and duties that I think are implicated by this. Rule 1.3, our duty of diligence, that we need to act with reasonable diligence and promptness in representing a client. So again, if something prevents us from being prompt, what is it? You know, and again, let's not look at this from, oh my goodness, the sky is falling. But again, we're here to emphasize the resources that are out there in Colorado. Think too about Rule 1.4. There are mandatory duties of communication, keeping clients reasonably informed about the status of a matter, complying with client requests for information, consulting with client about the objectives that they hope to achieve. All can be impacted if we are struggling with some sort of untreated issue. I'd even go down into the weeds of a lawyer's record keeping duties, because I see these all the time from the inventory counsel perspective. If your practice is too busy, or because you are struggling with other issues and you're not able to keep those required records that you have to keep regarding, say, your trust account, you're not reconciling your trust account on a regular basis because other things are taking up your time, that can impact rules of professional conduct. So those are some rules that I see coming to mind. Anecdotally, I think if you talk to lawyers in our office, they could say that it's not uncommon that we see that maybe there is some sort of substance use disorder or mental health issue going on, where we think that, but we don't know about that for sure because it's not offered as a mitigating reason for the conduct, but maybe it's there. The only jurisdiction that I know that actually has quantified this, we're going back to our friends in Illinois. Every year, their counterpart to our office puts out data on the number of disciplined lawyers for whom an impairment due to substance use or misuse or addiction or mental illness was an issue in the discipline matter. In 2020, this is their most recent report, of the 82 lawyers in Illinois receiving discipline, 24 of those had experienced some sort of impairment or mental health issue. I will leave to other experts to say whether that's something that we should use as a guidepost or not, but still we're looking at about 30% from that one state. And from following that on a regular basis, I would tell you all, it's usually about 30%, a third of lawyers in Illinois that statistic comes up. So think about it from a perspective of, I think it does impact our duty to our clients and the rules of professional conduct.
Yeah, thanks, John. And I think that number sounds right. I mean, it wouldn't surprise me if that many disciplinary cases did involve some level of substance use or mental health issues at some point along the way. I'm curious, though, what other states are doing around rulemaking and this idea of well-being and lawyer competency. I know there are a couple of states that have actually amended their competency rules to more clearly call out well-being and civility and professionalism as elements of lawyer competency. And so, Sarah, I'll start with you with the Kentucky rule. I think that's one that's a little bit near and dear to you in terms of how they've gone about trying to take us from having to extrapolate the well-being aspects of many of these rules to actually putting it in the rule itself.
Yeah, because this is obviously, I mean, you start regulating well-being and you're getting real tricky territory real fast. But without going into too much detail, what I will say is that I think the states that do it well, and this is not something, because of the way the Colorado rules are written, that we need to be adding to or anything like that with our rules per se, or has been looked at. But the idea that according to the Kentucky's rule, the comment is not intended to subject a lawyer to disciplinary action for showing signs of not being physically, emotionally, or mentally well, nor is it intended to expose a lawyer to discipline for not seeking help if struggling with depression, substance use disorder, or other mental health conditions or unhealthy behaviors. So I think if something's ever going to be added to a rule, making it that this is not to increase litigation, this is not to increase discipline. The purpose of this is to get people to get the help they need to avoid any kind of bleed into their professional conduct. So.
Great. And John, did you want to talk about the Vermont rule? Or would you like me to do that?
Actually, Ryan, I will let you take that one. Sorry,
okay.
I was on there.
Great. No problem. No. So Vermont has sort of a similar rule. What they did is they amended their comment 9 to 1.1 to read, a lawyer's mental, emotional, and physical well-being may impact the lawyer's ability to represent clients and to make responsible choices in the practice of law. Maintaining the mental, emotional, and physical well-being necessary for the representation of a client is an important aspect of maintaining competence to practice law. So they really do call it out more specifically, I think, than any of the other states that I've seen. And so, Sarah, I do think you bring up a good point in that it can get a little tricky to try to regulate well-being through these rules. But to that extent, to those folks on the call who may be thinking, well, I do see it as a competency issue, and what can I be doing in my own practice to make sure that I am showing up as competently as possible for clients? I mean, do you think that that's something that lawyers should be thinking about? I mean, even if the rules don't necessarily dictate it, should lawyers be considering how their own well-being and wellness is impacting their competency?
From my perspective, it's kind of what John mentioned, especially that comes down to communication with clients, which is certainly a concern for people now, because when our clients have a heightened stress level, it makes all of this even more difficult because possibly of their behavior. So now you've got not just the attorneys, but then their interactions with their clients. So to me, from your point of, do we consider this? Yes. I mean, all behavioral health issues are going to impact competency, because we're talking about the nervous system and brain functioning. Basically, for all of us, when we're overwhelmed and stressed, we don't make good decisions. I mean, this is just, everybody knows this. So when you're putting it into practice, to me, is how is this impacting my communication? Because when it comes to working in any pretty much avenue or branch of the law, that's where you're going to run into competency issues. Am I returning phone calls? Am I cool, calm, and collected when I'm talking to a client? Am I educating clients on the front end appropriately about the system, and managing their expectations off the bat to try to set up a really good foundation? That to me is one big piece of what in the practice of law we can be doing to work with our competency. And so on the side, we have to be managing our own stress levels so that we can show up in those communications as cool, calm, and collected as possible.
And I'll just add,
and Professor Austin, oh, sorry, go ahead, John.
I was going to say, one of the common complaints is, my lawyer hasn't communicated with me. I haven't heard from my lawyer in a long, long time. What's going on? All of us can say, well, that's just because practice is just really busy and really demanding right now. And it has nothing to do with a well-being issue, but sometimes it does. And so, communication with clients, and when that kind of starts falling apart, that can set off alarm bells. And the last thing, I'll be real brief, one of the reasons our office is interested in this conversation isn't necessarily from a attorney regulation. We're here to investigate issues where there's misconduct. I mean, yeah, as I said, anecdotally, these issues arise, but keep in mind too, that we are charged by the Colorado Supreme Court with also helping lawyers successfully navigate the practice of law. So to the extent well-being struggles are well-documented concerns for lawyers, as Sarah talked about and Professor Austin has talked about, we want to be a part of that conversation. And that's why this has been an initiative for OARC, and supported by both Jim Coyle, former regulation counsel, and current regulation counsel, Jessica Yates, because this does overlap with our need to help lawyers successfully navigate the practice.
Absolutely. And so, Professor Austin, I mean, what are you telling law students about this correlation between competency and well-being? I mean, how do you approach this subject with them and help them to start thinking about this as early on as possible in their careers?
My approach with law students is to invite them to do skill building, and to realize that they can build and protect brain health and mental well-being at the outset, starting in law school, and that they need to do that to be able to protect their competence and perform well. And so that's my approach, is to invite them into the skill building mode, and to also emphasize that taking time for your well-being is not selfish. It's the only way we can serve others.
That's great. And I think a lot of practicing lawyers could benefit from that skill building as well, if they didn't have the benefit of your classes in law school. But yeah, I love that notion of, self-care is never selfish, in the sense that we have to put our own oxygen masks on first to serve our clients in the way that we need and want to. It's a great question from the audience, and I am curious as to all of your opinions on this, but the question is, what are your thoughts on the language of Rule 1.16A with respect to lawyers with disabilities? And I think that that's a really good question, because I think this conversation around well-being and how we kind of dance around the topic of, where's sort of the line between, oh, it's just a self-care issue versus, maybe this is something that is more of a disability for folks. When we're talking about competency and elements of well-being that may materially impact somebody's ability to represent a client, how do we take into account lawyers with disabilities? We certainly don't want to, make the assumption that anybody with a disability is then not competent to represent clients. So how do we kind of draw that line and help to sort of sort out what is more well-being and what is something that does materially impact a lawyer's competence? And I'll start with you, John, just because you're in the office that has to consider that, I think, a lot of the time.
I think the question comes down to, our office, we are our system of complaints is driven by, clients and people calling and saying, this representation, I was concerned about it for this reason. And as I said, communication is frequently a reason that a call comes into our office. Misuse of client funds, whatever the concern is, the issue has become one where client harm has resulted, or there's a perception that client harm has resulted. In terms of answering, how do we look at that with Rule 1.16 little a, I think that, the question is really, it's is whatever the condition one that has resulted or could result in client harm. And so I think we need to look at, is it a wellness issue? Is it a systems issue? That this person has too much work. What is ultimately the problem, and how do we address that, and how do we encourage lawyers to address that professionally? And whether that's seeking a mentor for the systems questions, whether that's going to collab. So when I look at any of these rules, whether we're looking at 1.16, 1.1, 1.3, the duty of diligence is, has whatever gone on resulted in some sort of appreciable client harm that has taken place. I think that's a lens that we need to look at this through, as opposed to what does the rule language necessarily say, because I think there's defined terms like, well, what is that physical or mental condition that materially impairs the ability to represent the clients? I mean, we could have a whole webinar on what that language should mean. I think ultimately, did it result in client harm?
What about you, Sarah? How does COLAB approach these conversations, especially with lawyers who are seeking help, to help them or to assist them in sort of understanding for themselves where they are on that spectrum of everything from, this is just a pressure point to this is a disability and everything in between?
Yeah, so when members of the legal community call, we have a staff of clinicians who are highly trained to work specifically with attorneys and judges, law students, and again, family members we don't conduct psychotherapy or prolonged counseling, because there are many hundreds of thousands eligible for our services, and there's only a couple of us. So what we do is we use our expertise in a short amount of time, usually it's an hour-long consultation, to look at whatever issues are coming up for people. Lawyers have nuanced issues. It could be they're having problems with cases or have ethical questions. So finding them, for example, getting them to the ethics hotline to answer some of those questions, versus somebody who's looking for help getting into, or for a family member getting into residential treatment for substance use or mental health issues, versus just finding a therapist, again, like I said earlier, or a career counselor. It could be whatever resources that person needs. One of the biggest things we do during our calls, which again are free and completely confidential, we have a heightened level of confidentiality per Rule 254, is to normalize the situation. So we do a lot of psychoeducation around, this is what you're talking about. This is kind of what it looks like, but we're not doing assessments and we're not doing screening. So what we're doing is we're helping people get to where they need to go for all those. So kind of a hub of resources, if you will, because a lot of people don't even know where to start when they're dealing with the issues like you were just talking about, or these kind of concepts.
That's great. And so we only have a few minutes left, and I want to get back to Hannah's question from earlier about just sort of how we might be able to even rethink the legal education system or alternative paths to licensing to make some of these issues less of an issue, to make this, to make engaging in this profession more empowering. And I'll look to you, Professor Austin, just because you've got the best viewpoint into legal education, but are we considering this? Are we looking at different ways to have people join the profession to make well-being, civility, professionalism, all of those correlating concepts, easier to manage as a lawyer or as a person within the legal profession?
I would say mostly no. We are very steeped in tradition and doing things the way they've always been done. One big step we're taking is just to accept GRE scores in addition to LSAT scores for admission. That's like a giant leap for legal education. So these changes come slowly, and I'm not even sure demand by law students will cause the changes. I think they're going to have to come from the profession.
Yeah, that makes a lot of sense. Okay, so in this time we have left, if anybody else has additional questions, go ahead and put them in the chat. John, there's an additional kind of follow-up question about the language of the rules and whether they're biased against lawyers with disabilities. And I don't know if you want to say anything about that or any discussions that your office has had to look at that issue, especially with the aspect of disclosing disability. If you just want to comment on that.
I'm not aware of an effort to necessarily look into that issue vis-a-vis the rules of professional conduct. And I can't say whether, there's any sort of movement afoot. Maybe that is something to be looked at. I know our office over the years has made a concerted effort through the Office of Attorney Admissions to explain to law students that the best case example I can think of is having received some sort of DUI, or there's some sort of other mental health struggle that a law student has been working through over the course of their law school career and maybe beforehand, to explain that is not in and of itself a reason that you will not be admitted to the bar, that the focus is what are you doing to address the issues that were highlighted by that mental health issue or by that citation. How are you proactively addressing that? I think the concern is, are we taking proper steps to care for ourselves, and steps that ultimately, if you become licensed as a lawyer, will help protect clients and allow you to thrive. So that is an example from the area of admissions. Not from the rules of professional conduct, because as I said, I'm not aware of a desire or a movement afoot to look into the rules and their wording.
Thanks, John. Another question here. Do you have any insight on how young lawyers should approach the possibility of getting overwhelmed in litigation? For instance, where do we know where to draw the line between I need to push through this and this is too much, now causing me to question my ability and duty? Young lawyers feel especially unsure of themselves, and so it's hard to make that judgment call. Any thoughts on that, Deborah or Sarah?
Sarah, I'll defer to you. I think this is more in your ballpark.
I would just say that, yes, we receive many calls of that nature, where people again are questioning, and it can be new lawyers, but it can also be individuals of any phase in their career in the practice of law, where those kind of questions come up. So we regularly are again doing consultations on those sorts of topics and finding either resources for an individual to help continue that question to make their decision, or in the course of our conversation, help somebody brainstorm and clarify what they mean when they're looking at those issues, because that's what we need as human beings a lot. The way our brains work is sometimes it's through dialogue, it's through conversation that we really come to know what we actually want versus what somebody else is expecting of us. But it takes that dialogue to get to that place.
Yeah, and I will say, as a recovering litigator, I have been there. So for that person who asked that question, feel free to reach out personally. I'd be glad to chat with you about sort of my journey and if that's helpful at all. But I think mentoring can also be helpful, just to talk to other people who are in it, get a sense from them as to where their pain points are and their best practices and tools for overcoming that, and then knowing when you do need to make a shift. All right, well, it's 1 o'clock and we're out of time. So thank you so much to our panelists for being here. I thought this was a great conversation. We could probably go on for another 3 hours. I just did put the CLE affidavit in the chat, so feel free to download that and take it with you. I'll leave it up for a few minutes. Sarah, there were a couple of chat comments that are specific to COLAP. If you want to talk to those folks specifically, I'll leave the chat up so you can connect with them. But please join us next month for our next CLE event. It's on February 17th, same bat time, same bat channel. And we'll be talking about charting your public service or public interest career pathway. So if that's of interest to you, please join us for that great panel. But again, thank you, Professor Austin. Thank you, John. Thank you, Sarah, for being here. All of these folks are available to you for questions and continue to be a resource. But thanks, everyone, for joining us, and we'll see you next time. Take care.